Hello everyone, this is MAHEK, legal internet LEXIS and company. Welcome back to our channel. Today's topic of discussion would be doctrine of frustration. In under Indian Contract Act, we have six ways by which we can discharge our obligations that has been obligation that came from a contract two parties have signed. These six ways include by performance of actual or attempted conditions, by agreement or mutual consent, by lapse of time, by operation of law, by impossibility of performance, by breach of contract. We are concerned only with the fifth clause, by impossibility of performance. This has been enumerated under section 56 of Indian Contract Act. The bare words of section 56 are: a contract to do an act which, after the contract is made, becomes impossible, or by reason of some event which the promiser could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. So section 56 says when the contract is when two parties come into a contract and at that time the contract was capable of being performed, but due to some circumstances independent of their control, or such circumstances that cannot be contemplated at the time when they have entered into the contract, rendering the performance of the contract as unlawful or impossible. Those circumstances would be termed as subsequent impossibility, and the contract in those circumstances would be considered as void. Means the parties to the contract would be discharged of their obligations for performance of this contract. They need not to perform the contract anymore. So now this was what the subsequent impossibility means. Now we'll discuss about the frustration doctrine, and this doctrine of frustration was first evolved under English law in Taylor versus Caldwell, where it was recognized that when the circumstances were not favorable to the terms of the contract can be held to be discharged and the persons are not bound to them. But earlier it was the Supreme Court in Satyabrata Ghosh versus Mugniram said the doctrine of impossibility of performance of the contract the doctrine of frustration is based on the impossibility of performance of the contract, and these change circumstances are nothing but the supervening impossibility that has been defined under section 56 of Indian Contract Act. So the doctrine is nothing but a special case of our Indian section 56 of the Indian Contract Act. While discussing what this doctrine of frustration means, court said while discussing what does this doctrine of frustration mean, court said these are nothing but the occurrence of an intervening event or change of circumstances so fundamental to be regarded as law, both as striking at the root of the agreement and as entirely beyond what was contemplated by the parties when they entered into the contract. So this definition is similar to what has been defined as intervening, supervening impossibility. It's a doctrine of frustration is in simple words is nothing but when the terms of the contract had been struck by the change in circumstances, and those circumstances are so material to the contract, to the terms of the contract, rendering it as even impossible or unlawful to perform the contract. The parties and those circumstances it cannot be contemplated at the time they have entered into the contract. In those circumstances, the parties can declare themselves to be discharged of their obligations, and they just need to compensate each other for the gain or loss they have. For the gain, they have already benefited from the terms of the contract. Some of the instances covered under supervening impossibility is destruction of the subject matter. It's very simple when the very essence of the contract has been destroyed. For example, if the contract is for for building of a school, and but that land has been seized by the government. So the very subject matter, the land, had been destroyed, so the contract has been discharged per se. Then we have unanticipated change of circumstances. For example, if the contract is for delivering 100 kilo of plastic, and that certain type of plastic has been banned by the government to government for personal for retailing at the personal at personal level. So those will be the unanticipated change of circumstances. No one could have contemplated that all of a sudden the government would impose ban on those plastics. Then we have non-occurrence of contaminated event. For example, if the contract is that you would be giving us the ship, if and we'll be providing with you the material, the material that would be imported from the foreign countries. Neither the material was never delivered, so the ship was never made. So they were held to be discharged from their obligations to make the ship. Then we have death or incapacity of the promiser. If the contract is A would draw a painting of B by himself. A died. The painting of B could not be prepared by some other person, because it was something that would have done by A on his individual basis, so that the contract would be discharged. Some things that would not be covered under the supervening impossibility would be self-induced frustration. If the parties have done something if the parties have done something that had rendered the contract void, those would not be covered under supervening impossibility. That would have been covered under other sections of the Indian contract, but not under this. Difficulty of performance. Impossibility of performance is different from the difficulty of performance. If government said that the plastic could be only bought from only 2 shops in a country, it would be difficult to buy that plastic to sell, but still the plastic is available. The very essence of the contract can be preserved. Impossibility due to default of a third person means the ship wala case would be included here. Strikes, lockouts, and civil disturbances, these are all of temporary nature, and could be derived from earlier situations. So they are not covered under supervening impossibility, because they are in the hands of the person. And when the contract is based on 2 or more objects, and if one object is frustrated, then the contract still subsists with respect to other objects. What will be the effect of supervening impossibility? Section 56 is very clear on this point, that any agreement when strike with the supervening impossibilities, the agreement would be discovered to be void, and the person would are no longer bounded with it, provided they need to make compensation to the person against whom they have benefited, they have gained something from the very contract. This was all about this supervening impossibility. In the next video, I'll be discussing about Satyavrata Ghosh. That was a landmark case on this section 56, in which the court has this doctrine of frustration in applicability in the Indian laws. Thank you.